Right here, what we're going to do is go through some quick introductions, and then we will go through some do's and don'ts when it comes to early stage legal stuff for startups. And then we'll start taking questions that founders may have on your journey to go from startup to scale up, really. There are no wrong questions, and there's no need to be shy. For those of you that are tuning in via the live streams, just remember we are unable to monitor your questions there live, so please do join us here on Microsoft Teams. It's audio only, and anyone can join. Simply go to our website, startuptoscaleup.club. There you'll be able to find today's session, which is Startup Legal Q&A 04. Click join, quick registration, gets you a link to your email, and you can join us through that link. And then when you're in the Teams chat, then Teams call rather, sorry, you can drop your question in the chat and we'll give you the mic. But for now, we'll go through some quick introductions, then some do's and don'ts after. But initially, as for introductions, my name is Anton Call. I'm an Albanian in London, working with startups normally right after they get investment. I embed within their teams and help them hire and keep the right people. I do some growth advisory work with a few other startups and accelerators. And lately, I've been helping some angels and family offices with their due diligence and their assessments. So today, we'll start with our lady of the house, Ishita. Then we will go on to Saman, then Graham, then Kevin. Please take it away, team.
Hello, everybody. I'm Ishita Luthra. I'm a dual qualified lawyer working in India as well as in the UK. I'm a senior lawyer with Sprint Law UK. We're a small legal tech a law firm, you could say, advising small and medium-sized businesses with their legals. We've won a bunch of industry awards in the UK as legal innovation. And I have a background in corporate and commercial laws, and I've also authored a book called The Inner Circuit for anyone who is, undergoing stress or anxiety and is looking for, a roadmap for mental peace and clarity. It's great to be here speaking with you all, and I look forward to having a great session. Thank you.
Hi, I think I'm up next. I'm Saman. Lovely to meet you all. I specialize in going into early stage startups and scale-ups of the general counsel on a fractional basis and embed within teams as the in-house legal support and advice from there to help startups avoid costly mistakes, to speed up time to revenue for enterprise-facing customers, and generally give sort of overall strategic legal advice and support. So that's my main role as a fractional general counsel, and it's great to be here. So happy to answer questions across most topics that the startups will come across day to day.
Hi everyone, my name is Graham Halliday. I'm a partner at Marriott Harrison. I'm an English qualified lawyer based in London. I specialise in venture capital transactions, and my firm works with both startups right from inception all the way through from pre-seed, seed, Series A and beyond to exits and listings. We also work with some of the most well-known venture capital funds in the UK and Europe, such as Beringer, Northzone, Alderton, Excel, etc. And we really love working with startups right from the beginning and helping them right through their journey to exit.
Guess that's me now. I'm Kevin Withane. I'm the co-founder of Impact Lawyers. We provide legal and business services to investors, founders, and SMEs. We have offices or lawyers based in China and the US as well. For me in particular, I focus on supporting investors and founders, everything from early stage funding round to helping them with their day-to-day legal support to right through to exits. And I work with funds as well to help them avoid early zombie syndrome and get into their companies, restructure those companies that have come off the growth curve to help them get an exit before they lose the cash that they invested. And that's me.
Well, thank you very much to all four of you. That is some impressive backgrounds. What we're going to do now is perhaps hear what your do's and don'ts are when it comes to early stage legal stuff. Maybe we can start, tell you what, let's start with Kevin, and then Saman, then Graham, and then Ishita, please. If we can think of one do and one don't each, and maybe we can try not use the same for both do and don'ts, and let's see where that takes us. Kevin?
Do try to accelerate quickly and find hacks, but don't make your hack ChatGPT instead of checking a lawyer with a lawyer.
Yeah, I'll go next. I think do think about IP protection from really early on, because the value for tech companies is in the brand. So get that protected, and don't ignore legals. You know, it's about getting the right advice up front, not about spending huge amounts of money on it. So I think getting the right advice from the right place for people who understand risk is a good idea. So don't ignore that, and sort of plow through blindly without thinking about it at all.
Don't would be don't sign a term sheet for investment round before you get your lawyers to look at it, because it's very hard to unwind it after it's been signed. And do make sure that you own the key IP in your business, that you need to run it. Otherwise, you have a lot of complications with due diligence in investment rounds.
I'd say do think about when you start your business, how you want to structure it, whether you want to be a sole trader, whether you are in partnership with someone, or whether you want to set up your own limited liability company, because under law, a limited company is a separate legal person. So that kind of separates legal liability between an individual and an entity, a legal person. Before you build any product or start, selling any goods or services, think about the legal structure that you're going to use, especially if you're going to be registering your trademarks and creating IP. Don't would be well, can I think about it and come back to you, Anton?
Absolutely, you can. Not a problem at all. Thank you very much, Ishita. And thanks to all of you for these gems. And I guess a quick reset of the conversation before we get going with questions. This is Startup Legal Q&A. It's our 4th edition. We've started the legal Q&A this year. However, we've been doing these sessions for 4 years now. And the idea is to help startups with whatever questions you have. Basically, try and help founders go from startup to scale up with on-demand tailored advice from people who've been there and done it. And these are our legal eagles. In terms of your questions today, they can be on anything to do with that sort of the landscape, the legal landscape. So whether you want to talk about founder agreements, or maybe just starting with incorporation, or perhaps then shareholder rights, IP, term sheets, compliance, regulatory, NDAs, employment law, legal documents, templates, contracts, disputes, you name it, this is the place to ask it. There are no wrong questions, and there's no need to be shy. It's a learning curve for us all. Quick reminder for those of you that are tuning in via the live streams, whether that's LinkedIn, YouTube, Facebook, or Instagram, please be aware that unfortunately we're unable to monitor your questions there live. So if you do have any questions for us, you'll have to join us here on Microsoft Teams. The quickest way to do that is go to our website, startuptoscaleup.club,
click on today's session, which is Startup Legal Q&A 04, then click join. It's a quick registration. That gets you a link to your email. And through that link, you can join us. When you're here, all you have to do then is type your question in the chat. We'll give you the mic and you can ask this amazing team. We're only going to be here for the next, 4 to 6 minutes now. So I would suggest you don't leave it for last minute, as often when that happens, we then run out of time and I keep getting hounded by people with messages. Please, one more question. By the way, if your questions today are not on the legal aspect of startups, then save it for the other sessions we do. We currently run 6 regular sessions. Monday's talent, Tuesday's product and tech, Wednesday's growth, Thursday's fundraising, second Friday of each month it's legal, as you can see today, and third Friday of each month it's finances. They're all from 12 to 1 p.m. UK time, and you can RSVP to any of them via our site, startup2scaleup.club. And actually, when you go there, you might want to join our WhatsApp community, which is groups of founders, investors, and operators that you can interact with. And one last reminder, our amazing panelists are what makes us work. Without them, we wouldn't have any of this, and none of these opportunities would be available. They do this for free so that they don't have to do other stuff for free. So bear that in mind. But in the meantime, feel free to follow them on LinkedIn and kind of show them your love, really. I guess with that in mind, we can now start with some questions. I've put one in the chat for the team here to see, but I will read it out loud for those on the live stream. So this is a creative agency in Cornwall, they're in Truro, and she says, as a co-founder of a creative agency, I'm considering selling a portion of my shares to a new investor to bring in fresh capital. However, my other co-founders are against the idea. What are my legal options if I want to move forward with a sale? And how can I maintain the agency's cohesion and long-term objectives during this transition? Ah, boy, why can't you be here? I get why you may not want to, though, but all right. How about this? We will start with Simon, then Kevin, then Ishita, and then Graham, please. Let's try and keep it about a minute each, please, team.
Sure, I'll be fairly brief. I think the corporate guys can probably help more, but I think it ultimately depends on the ownership structure. How many, if you're the majority owner and you have, you know, the power to make decisions by yourself legally, you can probably push through the sale. The question then will become, how can you maintain cohesion? And I think that obviously depends on the strength of your relationship with your co-founders and how you can influence them in understanding why this is a good decision. But I think it's a complex and tricky question on the non-legal side, and the legal side will depend on, you know, how much you each own and whether you can actually force something through individually with the shares that you own.
I hear Kevin. Are you audible, Kevin? You probably, yep.
Can you hear me? Can you hear me?
We can now, Kevin.
Hello?
Yes, we can. Yeah.
Can you hear me?
Yes, we can, Kevin. Can you hear us?
Hello? Can you hear me?
We can hear you, but I guess your internet is not that great at the moment, but we can hear you.
Can you hear me now?
Kevin, yes, we can. Can you hear us?
Can you hear me now?
Yes, we can.
Yeah, I'm
Kevin,
gonna try and log off and then come back in.
good
Sorry.
one. Good one. No worries. Okay, let's go to Ishita and then Graham, please.
Well, if you are looking to raising investment in the company, then you'll have to issue new shares, which is why you need the other co-founders on the board, especially because there may be statutory preemption rights that apply, so you need to check your articles, what's in there regarding issuance of new shares. Because if you sell your shares to the investor, then the company will not receive any monies. It'll be yourselves in your personal capacity, or if you've invested by a company. So yeah, it's worth checking the articles, and then, like Saman said, having that cohesion with the other co-founders and reasoning whether the investment is a good option for the company's growth and long-term objectives. Yeah.
Thank you, Ishita. Yes, Graham.
Hi. So I think it does slightly depend, as you're just saying, on actually what we mean. Do we mean issuing new shares, or do we mean selling existing shares, and whether the company's going to the money's going to the founder or to the company? I think if it's a sale of shares, the money's going to the founder. It's probably a little bit easier to sell shares. You might have to go through preemption rights, but generally you are free to sell the shares. If you're looking to issue new shares, then you would most likely need the board to approve that. So it depends on what the makeup of the board is. There's other founders on the board, you may need to convince them, and also, as you're saying, depends on the shareholder structure as well. You need to probably pass certain resolutions, so who holds the majority. And so whether, I suppose, either way, if new investors coming onto the cap table, then I think some of it is about controls as well. So having sort of long-term objectives and cohesion with the existing founders. I suppose it's making sure that the new investor doesn't have too many controls, can't block too many things, and that obviously probably ultimately depends on how many shares that they will hold. So you can sort of structure and tailor shareholders agreements and articles to limit that, and make sure that that the existing founders control the business going forward.
That's a very good point. Thank you, Graham. Kevin, are you audible now? Can you hear us?
Can you hear me now?
Yes, we can. Can you hear
Yeah,
us?
yeah, I can hear you.
Good man. Did you hear the question earlier?
Is it the one about selling shares to a new investor?
Yeah. So this lady in Cornwall, she's got an agency. What are my legal options if I want to move forward with the sale? So, the way she's framed the question is selling a portion of her shares rather than issuing new ones, or at least that's how I'm understanding it. And again, it's not very easy for us to answer these if they're not here for us to query and kind of follow up. But still, I kind of get it why some people may be reluctant to kind of put a name to a face, if that makes sense. What would you do?
Yeah. I think Graham pretty much covered that comprehensively, but I would say, like, there is a difference between selling your own shares or issuing new shares to the company. She sort of talks about selling her own shares, but then capital coming, getting a fresh capital into the company, or which suggests that if it's going to go into the company, it'll be the company issuing new shares, and if she's selling her shares, then she'd get the cash. So she sort of needs to work out, and if it's the latter, then I sort of can understand why a shareholder or her co-founder sort of objecting. But there probably isn't much you can do. I mean, you'd obviously, without seeing the articles or any shareholders agreements, a little bit blind. But issuing new shares, as Graham said, like, you'd need board approval and shareholder approval as well, most likely.
Fair enough. That makes sense. Thank you very much to all four of you for that. Right here, I guess we can go to another question. Again, a reminder, for those of you on the live streams, please remember we're unfortunately unable to monitor your questions that are live, so you'll have to join us here on Microsoft Teams. You can do that by going to our website, startup2scaleup.club. Literally, just find today's session, which is Startup Legal Q&A 04. And by the way, this is for questions from startups in the UK. So this is about UK startup law. And we're here to help you with some of the top people in our ecosystem, providing answers to some challenges you may be going through at the moment. So to jump onto the Microsoft Teams call, if you click join under the event there, Startup Legal Q&A 04, it's a quick registration that gets you a link to your email, and via that link you can then join here, and then all you have to do is literally just drop the question in the chat and we'll give you the mic. We're only going to be here for the next 36 minutes, so we'll go on to some other questions that were sent in. This is about data sharing. It's a health tech startup in Devon. He says, we're a health tech startup. Sorry, I'm a health tech startup co-founder, 1-5 out of 5. I'm assuming he means there's 5 co-founders. In Devon, offering a platform for telemedicine consultations. What are the legal considerations for including data sharing clauses in our terms and conditions with clients and healthcare vendors? How do we balance our obligations under GDPR, the UK Data Protection Act 2018, and the NHS Data Security and Protection Toolkit? I'll give this to the team in a second, but as somebody who is GDPR certified, but this is for my HR work rather than this kind of stuff, I would say you need to be, especially when it comes to health data, you need to be very, very careful. The idea is that basically you've got to have at least one person in-house that is the person that manages and deals with that data. And I wouldn't just second guess it. So either there's 5 of you, one maybe who's more sort of knowledgeable about this stuff. Maybe they should go and do a course. I've done a few courses, and the latest one was literally something that I did online, and then they tested me on it. I think it was about an hour and 45 minutes test, and then they gave me that certification. You also need to register with the Information Commission. They've got some extensive work there. Unfortunately, I don't know much about the NHS Data Security and Protection Toolkit, but hopefully some of the lawyers here might have some idea. So we start with Ishita, then perhaps we can go to Graham, then Kevin, and then Salman, please. Ishita?
Yeah, I'm not a data protection lawyer, but I do have some idea. Maybe my thoughts could help. Well, because this platform is client-facing and vendor-facing, so if you are using or processing personal information of UK clients or residents or nationals in the UK, and you're sharing it with healthcare vendors who are outside of the UK, then you need to think about how you are sharing or transferring that data outside of the UK. You may need data transfer or data sharing agreements based on the jurisdiction. There are jurisdictions which have an adequacy regulation with the UK, which essentially means that their laws are aligned with the UK GDPR and the EU GDPR. So there is a list of jurisdictions which fall under the adequacy regulation, and then there are others that don't. So depending on the jurisdiction, you might need to have, those kind of agreements. And I think Saman is a better person to speak about this. I'm not aware of the NHS Data Security Protection Toolkit, but those were my thoughts primarily on this point.
So I don't specialize in data protection either, so I don't know a detailed exact answer to this, but to sort of try and be helpful. I think, as Anton alluded to, health data, you need to be incredibly careful with it. My understanding is, I believe it's a higher category and a sort of a more of a protected set of data compared to other sets of data. So there'll be sort of additional obligations on there. But I think at the very least, you will need at least need consent from the individuals that give you the health data to actually be able to pass it on to other third persons. And certainly you need to make sure you're not holding on to this data for any longer than you reasonably need to, and should delete it once you've used it for whatever you need to do. Others might have more background and experience on that, but I have colleagues as well if the individual does want to reach out and I can introduce them.
Thanks, Ryan. I believe it was Kevin and then Simon, wasn't it? I can't remember which one of you, either one.
Sadly, I have done a bit of data protection and GDPR. I spent quite a bit of time when I was in-house dealing with that. Yeah, health is you have potentially having a lot of more sensitive data depending on the type of data. It's really hard to obviously answer this question without seeing the specific types of data. It is possible to do probably share some data, but you need obviously to be very upfront with what's being shared. Sensitive data, there's going to be some restrictions around, but without seeing the types of data you're looking at, it's hard to sort of give you conclusive advice. But what I would say is it is a very tricky area. Go and get some specialist advice on it.
Yeah, I think the guys have covered things fairly well. I think as the final person going and someone who has been a DPO and has worked with data a lot, I'd say I'd take a step back from, what are the terms and conditions I need to put together. This is more about a holistic approach to, data management. So it's sort of privacy by design thinking. So what you really need to do, I think, is understand what data you collect, map it against what sort of third-party and in-house tools it goes through, i.e. what are the data flows. And once you understand those data flows, you also need to understand, are you a controller of the data or processor, i.e. are you making decisions based on that data or simply processing it on behalf of the vendor or on behalf of the client. And then once you kind of start understanding those things and have mapped those out, then it's about getting the right contractual arrangements in place. But I think it's about getting upskilled on what you need. And like the guy said, it's when you do need, if there are justifications and lawful bases for processing the data, which presumably there are if the client wants you to and the vendor is happy for you to have it, then it's just about documenting that and actually building processes within your business to make sure you remain compliant as opposed to treating it like a tick box exercise. And then as the guy said as well, only store the data as long as you need it, delete it, think about encryption and anonymization where you can and things like that as well. But yeah, ultimately, I think you need advice and kind of doing a bit of a data project to understand what you're doing and understand what you need to do to remain compliant.
That's some very good points. And if I may just kind of add, but also reiterate, as a rule of thumb, you need to remember that if you handle anybody's data in the UK, you have to register with the Information Commission and also pay a yearly fee. Number two, in terms of a rule of thumb, if your data is stored in clouds or somewhere that is outside the UK or outside the EU, then you've got some trouble there that could brew. And also, as the team mentioned here, things like the timeline, as well as anonymization and security side of it. These are all things that you have to have in place. In terms of the NHS side of it, again, sorry, but it's not really my forte, so I won't even try and go into it, but you definitely at least get in touch with the Information Commission. Rightio, it's now 12:33. Just a reminder, if you've got any questions on the legal side of running your startup, this is the forum to ask it. We do this once a month, and you can ask us any questions to do with your legal landscape, whether that's incorporation, founder agreement, shareholder rights, IP protection, term sheets, compliance, regulatory requirements, NDAs, employment laws, legal documents, templates, contracts, co-founder or investor or board disputes, and all that jazz. There literally are no wrong questions, and there's no need to be shy. It's a learning curve for us all. For those of you that are tuning in via the live streams, whether that's LinkedIn, YouTube, Facebook, or Instagram, please be aware that unfortunately we are unable to monitor your questions live there. So you'll have to join us here on Microsoft Teams. The best way to do that, or the quickest way to do that, simply go to our website, startuptoscaleup.club, find today's session, which is Startup Legal Q&A 04. Click join, quick registration. That gets you a link via email, and on that link, you can join us here. It's audio only, which means it's flexible and secure and accessible from any device or platform. And once you're here, all you have to do is just drop your question in the chat. We'll give you the mic, and then you can ask our team. If, however, your questions are not on UK startup law today, then please save them for the other sessions that we run. Mondays, it's talent. Tuesdays, it's product and tech. Wednesdays, it's growth. Thursdays, it's fundraising. Second Friday of each month, as you can see today, it's UK startup law. And third Friday of each month, it's UK startup finances. They're all from 12 to 1 p.m. UK time. You can RSVP to any of them via our site, startup2scaleup.club. And actually, when you're there, please join our WhatsApp community. It's groups of founders, investors, and operators that we have there. And you'll also get the alerts for future conversations. Although we've had 280,000 people join us in 4 years, because we've changed 3 platforms in the last few months, I think we need all the help we can get to spread the word. So if you are finding any value in this, please feel free to spread the word. So we'll now go on to another question that was sent in. This is from a digital media startup. They're in Leeds, seed stage, and the problem they have is basically protecting IP when outsourcing development. So they go on to ask, our digital media startup in Leeds is outsourcing a development of a new mobile app to an external development team. How can we ensure that the intellectual property generated during the development of the app remains fully under our ownership? What terms should we include in our contract with the development team to secure the transfer of all IP rights? And how can we ensure that the work completed does not infringe on any third-party IP? Additionally, how can we protect the app's user interface and unique features once the app is launched to the public? So I guess there's a few questions here. How to protect IP generated during that work, what terms to include, and how not to infringe on third-party IPs, and last but not least, unique features of the app's interface. So that's 4 questions. Personally, I think the interface, there's only so much you can do. You might, get some kind of trademark or whatever, but people are going to find ways to go around that, to be honest with you, if they really want to. In terms of the IP itself, then personally, I would only focus on maybe some of the data and the way you do things rather than the actual technical thing. But again, it depends what you're doing, of course. So I don't have enough information, but hopefully our brilliant lawyers here will be able to give way more advice than I am. So maybe we can start with Graham, then Saman, then Kevin, then Ishita, please.
So the default position, if you just did nothing, then arguably the developer would most likely own the IP in the app. So what you need to do is transfer that IP to the company, and under law it needs to be a written assignment. So under that contract, you want to make sure you have an IP clause which actively assigns all IP in development of the app to the company. You need to be careful of the wording, because often when I've done sort of due diligence on behalf of investors in companies, you might have these kind of contracts and it says, oh, the company is entitled to the IP, or will own the IP, or the developer will assign it. But the problem is that's not actually an active assignment. That kind of suggests something else needs to happen. So you need to make it very clear that the IP is assigned to the company under that contract. And in terms of ensuring that the work completed does not infringe on third-party IP, I mean, that is difficult. You want, at the very least, in that contract, the developer to give warranties to say that that the IP that they're developing for you does not infringe, and potentially indemnifies you as well for any losses. And clearly, if they are if they believe there is a concern or issue, then they would probably be resistant to signing those clauses, and then obviously that's a red flag for you. So I think those two questions, and then on the interface, I think as Anton said, that is tricky. I suppose there'll be should be IP inherent in the development of the app, whether it is copyright in the software or the look and feel of it, or potentially trademarks as well. So if someone did try go after them for that.
Yeah, I think Graham's answered pretty comprehensively. So I think, thinking from a practical perspective, I think the way forward is get this contract reviewed if they have standard terms, because if they have standard terms, they'll be very supplier friendly. So don't just sign it. Get it negotiated. If they haven't offered you terms, ask for them, or think about getting a lawyer to draft them for you, and cover off those key points that Graham mentioned within that, and make sure the wording's satisfactory. I'd add that third-party IP indemnity that Graham mentioned should be unlimited in terms of it should be outside any limitation of liability cap that's included in the agreement. And then, yeah, in terms of the UX, sort of the interface, the copyright would generally be in the code. If someone created something that had the similar look and feel to yours, but had been completely developed independently, it's unlikely that you would be protected. But equally, it's unlikely that they'd be sort of necessarily able to copy your exact design from, without knowing what your source code is. I think the key here is to protect the code, make sure you own it in the agreement we've talked about, and then I think from there you should be pretty comfortable going forward. And I think it's just key to get that agreement right, basically.
Thanks a lot, Simon. I think it was Kevin, wasn't it? And then Ishita.
So we sort of talked about doing the IP assignment, certainly with the developer. In every funding round I do, whether I'm representing an investor or the founder, we always end up doing an IP agreement, just signing an agreement to ensure the IPs with the company. Something that often doesn't, with the sort of point about protecting the sort of interface design, it potentially could register that as a design right, which gives some protection, but you need to look into it. But it sort of protects the overall look of the interface. But with all sort of technology companies, particularly at the stage of changing things, so it may not be a worthwhile use of funds to do that. Key processes, the algorithms, you can use something like trade secrets, sort of keep a register of those, and then you limit access to who can access that sort of proprietary information. It's not registered out in the public, but you sort of keep a register within your organization. You limit access, and you use sort of non-disclosure agreements or confidentiality agreements with employees who have access to it, or any third parties or partners that you might give access to it.
Just before we go to Ishita, Kevin, are you on the move? Are you out and about? Because you keep coming in and out, and it sounds like you've got a mic that you're holding, maybe the headphones.
I'm outside. Sorry.
That's right. No, that's all right. That's okay. Ishita, what would you do here?
I think Graham and Simon and Kevin have covered the overall, considerations here with regard to assignment, indemnities, limitation and liability, etc. I have two small but significant points. I think it's important to see You know, and also kind of add that as warranties in the document, that any intellectual property that the developers use to create the product, they have the appropriate licenses to do so from third parties, just to ensure that they don't infringe on anyone else's intellectual property rights. And also the definition of intellectual property is very important. It should cover everything around the product, whether it's trademarks, copyrights, designs, code, software, etc. So yeah, once I mean, whoever's drafting it needs to ensure that all aspects of the product are covered, and yeah, and maybe appropriate confidentiality clauses to say that the developer will not kind of disclose aspects of the development and, you know, the confidential information around it with any third parties. Yeah, pretty much that.
Thank you very much, Ishidan. Before we go to our next question, Kevin, you brought up something I've come across even yesterday, actually, when we were at the BVCA, which you were there as well. I was discussing this with a couple of people. One of them was a lawyer who was seconded to an organization and so on. But in terms of trade secrets, is there any rule of thumb or any advice that, you know, most startups maybe can do something about it? Is it costly? What is it advisable normally to focus on if you want to kind of tackle that? Any thoughts in terms of, you know, the current practices would be greatly appreciated. And then if the others want to add anything on that after you, please feel free to do so.
Right, I'm not a specialist in this area, but it's a simple document you create to sort of when the trade secret came into force. Like, is it an algorithm? What is it? Where is it located? And then it's also about limiting access. So once it's registered, whoever's responsible for retaining that register also sort of should probably have the power to give access to people, so it's not readily available. So like, you can just go to the, oh yeah, go and have a look at the album, do the fixes there. You would ensure that they've signed an agreement, and you also recorded when they were given access, and any changes made. You obviously, things like algorithms, things like that, any changes you want to sort of you should have good documentation around those changes anyway as part of your change management process. But I'd say it's relatively easy to do that, and then it's not something you go out and register. But if you see it then going into elsewhere, or something that looks like it's using your trade secrets, you've got a way of probably trying to find out the source of that and how it got out into the market.
I hear. So it's not a case of you having to register a patent or a trademark for it to be considered a trade secret.
No, which is why you won't find anywhere in the public, like, you know, Coca-Cola's magic secret on their Coke, or, you know, KFC's secret blend of whatever many ingredients they use for their chicken.
Fair enough. Yep, that makes sense. Did anyone want to add anything else on this, or? You don't have to, by the way, just thought I'd put it out there. Okay, well, thank you very much for that, Kevin. Thank you to the others as well for the previous answers. For the answers to the previous question. We now have 12 minutes to go, so we probably have time for another couple of questions or so. So if you are tuning in via the live streams and you're wondering, how do I get to ask this amazing panel, you have to do that here on Microsoft Teams. The best way to do that is to click on, to go to our website, and then go on to startup2scaleup.club, then find today's session, which is Startup Legal Q&A 04. You click join. It's a quick registration that gets you a link to your email, and you click on that link and you're here on our live audio session. when you're here, then you can type your question in the chat, and it can be on anything to do with UK startup law. So please feel free to do that. Otherwise, we'll go on to some more questions. So this is a clean tech startup in Inverness. And by the way, I've put that in the chat for the team to read, but I'll read it out loud for the live streams and those going through the recording later. So clean tech startup in Inverness. More aggressive growth strategy, as we're cautious about maintaining our sustainable goals. How can we structure our shareholder agreement to manage these conflicts? Should we include provisions for decision-making processes or deadlock clauses to prevent this from escalating? What legal actions can we take if investors try to impose a direction that conflicts with the company's mission? Before I pass you on to the lawyers, I don't want to say you're screwed, but I'd be really surprised, again, depending what investors you use, be really surprised if they didn't have on their term sheets stuff about these things that you mentioned, basically, in terms of shareholder agreements, how to structure these things, what happens in the event of conflicts, and so on. I'd be not surprised, I would be shocked if those investors haven't kind of thought of these in their term sheets. So you probably need to go back to reading the small print again. How do you undo that? I don't even want to start. But let's hear it from the experts. Let's start with Simon, then Ishita, then Kevin, then Graham, please.
Yes, I think this will depend on, again, what is the ownership structure of the business, what rights have, as Anton says, what rights have the investors taken at the previous funding round. If it's already been closed, it will already be in those documents, and they probably have seats on the board, etc. So I think at this point it's about understanding what has already been agreed, and understanding what decisions need board approval, what decisions can the majority of shareholders make, etc. So it's understanding your existing position. If you want to negotiate that position to become more favourable, I think, again, I agree with Anton that is a hard conversation with the investors. And I think non-legally, I'll make a quick point, because I think the corporate guys will make more legal points, is, are these the right investors for you if you're already in these types of difficult conversations, kind of like if you're not aligned on that path. And I guess it's also a question of thinking about, like, how, and I don't know how you do it easily, but are they the right people long term to grow the business with you? So I'll pause there, and I think the corporate sort of people on the call will have more ideas from a technical point of view.
That also brings up another point, that if they're not the right ones, how on earth do you get rid of them now, especially if you haven't got the money to buy their secondaries? Ishita.
Yeah, this is a tricky one, especially, if you've fallen out, the tension started. So it'd be hard to kind of renegotiate the terms of a shareholders agreement or investment agreement regarding how these have to be resolved. All parties need to be on board. Typically, shareholders agreement will have deadlock clauses. It'll be normally a typical, a neutral third party that the board or the shareholders will go to in the event of a deadlock. But I think deadlock clauses are typical in shareholders agreement, especially where there is an even number of shareholders or directors on the board. With regard to the investors trying to impose a direction that conflicts with the company's mission, you can have when you draft your shareholders agreement, you can have certain guidelines which you can, certain objectives of the company that you can incorporate in your shareholders agreement as guiding principles for making strategic decisions. And well, the investors, so you can't force those guiding principles on them, but they can just act, provide direction on making, like I said, strategic decisions. But yeah, this one is a particularly tricky one and maybe needs a bit more investigation.
Thank you very much. I think it was Kevin and then Graham, wasn't it?
I think we've covered a lot there. Yeah, obviously it's going to depend on. I think I say to every founder, every time you bring on an investor or investors, you're letting other people into your house, so be choose them very carefully. This typically comes at a later stage sometimes, like where there's a push for growth and pushing levers. Ultimately, it'll come down to what's in the shareholders agreement and what's in your articles about the rights that the investor and shareholders have and members or investors have. I'd be surprised if there isn't some investor consent, but pushing for growth, I don't see investors being able to essentially effectively do things. It's more when they have blocking powers on things that you want to do. But without obviously seeing the shareholders agreement, we're a little bit blind here. But I think that's the document. That's where you need to look to, like the shareholders agreement and the article, and see what things need to go and get investor rights. If they have a board seat, then they're potentially going to be more impeding and disruptive. A way out of it is potentially to look for somebody else to help you buy those investors out. They would be willing to do that if you get into a point where it's a very fractured relationship. But ultimately, you do have some sort of the bargaining chips as well, being able to go back and saying, look, everything you're doing is actually slowing us down, disrupting what we're trying to do, and it's actually devaluing the value of your holdings right now. So maybe we need to work out on a compromise.
Thank you, Kevin. Last but not least, Graham, please.
Yeah, I think everyone's sort of really touched on all the key points, and I think I would just reaffirm that I think the most really important thing is, what does it say in the existing documents? I think that's really probably the answer to the questions, because it's hard to say without seeing those. I think maybe Kevin mentioned that I'd be very surprised if the investors can force you to take a different direction. They may be able to stop you from changing direction or making big decisions under the consent rights. So I would be surprised legally if they can push you into that. I mean, with deadlock, if there aren't provisions in there, I would be a little bit careful about that, because some of those can be quite sort of nuclear options about if things can't be agreed, then there's options for each other, parties to buy each other out, and you don't want to open up the opportunity for an investor to essentially take over your business. If it is to be a case of they can't force you to do things and it's just kind of not working out because they're kind of impeding you or sort of being disruptive on the board by saying they want you to do certain things, and I think it is probably a case of having the conversations about whether this is working out and trying to look at options, perhaps them selling their investment to other investors. There's opportunities to do that on sort of secondary sales. So it is a tricky one, but I would be surprised if they can force you to do that. And maybe it's a case of you accept they're kind of a minority investor, and you almost potentially ignore them, and you just sort of crack on and maybe look for other investors, and they get diluted even further.
Thank you. Now, we've only got 2 minutes, but if we can quickly maybe touch on this, how easy or how often do you see this happening on two matters? Number one, renegotiating term sheets that were signed God knows how long ago, and or shareholder agreements. And two, in terms of buying back from the investors that have already invested in you. So in this case, these guys, how doable is that? Maybe we can start with Graham since you started, then Ishita, then Kevin, then Simon, please.
I mean, I think the kind of situation here that's been described is quite a unusual, quite a rare situation. Normally people sign up to sort of term sheets and shares agreements and get comfortable with it, and they often maybe get renegotiated in future investment rounds when other investors are coming in and sort of taking a higher stake, and the early investors kind of almost drop down and have less consent rights. So it is quite an unusual case. I think the scenarios where I've seen that it really kind of ends up with kind of a negotiation, and investors typically would probably sell their shares to another investor. I mean, you can do a share buyback, but that is tricky because to buy back for substantial amount, they would need to have distributable profits, and from my experience, that's quite unusual for an early stage startup. It's take a little while to become profitable, so that might be challenging to do.
Thank you. I think the next one was Ishita and Kevin.
Yeah, I agree with Graham. I think he's covered everything. Yeah, it's tricky in the sense that buybacks are, very unusual in the scenario because you need distributable profits, and if it's I'm quoting Graham, if it's a substantial amount that the company may not be able to fund it. So how do you provide an exit to the investors? Yeah, either you find a third party buyer, or you have existing shareholders buy out the investor. So unless there are provisions in the shareholders agreement which cover these scenarios, it's likely that they may be heading towards a dispute situation. Yeah, no, it's quite an unusual scenario.
Thank you, Kevin.
Yeah, it is unusual. I've actually seen a few instances in the last 12 months of things similar. It comes down to a negotiation, usually around this, and money. Can you afford, like, the share buyback is tricky because as Ishita and Graham said, like, you've got to have the distributable profits. You have to have sufficient cash in the bank for the business to be able to do that. And assuming if they're early stage or relatively early stage, they probably don't have that. And if the founders have sufficient cash, they might be able to try and negotiate a deal themselves. Any transfer of sale anyway probably might trigger a preemption right. So if you can get the investors to agree a sale, you might be able to get the buyers to be those who are existing investors. Also the valuation, what price are they going to sell up? Because I guarantee you the investors will want to have some upside, because they will feel like they're giving away future opportunity. So even though the valuation is why, they're going to feel like they should be asking for something a bit more because they're missing out on a future opportunity. You see it with exiting founders as well a lot. But ultimately, it would come down to, as the other said, an agreement that you can get with the investors, and having the sufficient cash there, or being able to find investors who will buy those shares. And then also, you've got to take into account the tax consideration. So if this was EIS or SEIS, is the investors who are causing the problems, are they going to get hit with that tax issue? But there are some things to consider.
Thank you very much. And last but not least, Simon, please.
Yeah, I'm conscious of time, and I think it's been pretty comprehensively covered, Anton, so I'm happy to leave it there.
That's pretty good. Thank you very much, Simon. Now, for those of you that are still here, apologies, I've kept you 3 minutes over the line. Do you have any parting words for us? Let's start with the lady of the house, and then Kevin, then Simon, then Graham, please.
Yeah, I'd just like to mention don't part with too much equity without understanding how much control and equity you're giving away. So just to add my don't there. Yeah, it's been a great session. I hope the audience got valuable insights into different aspects of the startup legals. And yeah, have a good weekend, everyone. Thank you.
Thank you very much, you too, Ishita. See you next time, I guess. Who was next? Was it Kevin, then Sam, and then Graham was next?
Yeah, I think my advice is particularly, I think Graham mentioned at the beginning, get a lawyer to look over your term sheet. When you negotiate to them, valuation is important. Don't spend all your time in that. As we've seen today, a lot of questions come around control, things can be done, and all of these, what you put those in the term sheet, you negotiate those in the term sheet, and then they end up going into the full legal documents. So spend time thinking on that, like what's practical. If your investors are asking for monthly reports that are extensive, that takes up a lot of management time. Can you effectively and efficiently do that? And if you start failing doing that, they get worried. So negotiate those points and make sure you come to a compromise that actually is workable as well.
Thank you, Simon.
Yeah, just to say thank you for a great session. If people have follow-on questions on any of the stuff we just talked about, especially the IP and the data stuff, I'm happy to have separate calls. So do feel free to reach out on LinkedIn and we can speak in a bit more detail about because I'm conscious some of the answers were fairly general because we haven't seen the docs. We don't know exactly the specifics of what's going on. So happy to fill people in a little bit more. And yeah, like Ashita said, have a great weekend, everyone.
Jane, thank you very much. Last but not least, Graham, please.
Yes, this really enjoyable session. It's first time for me, and it's really nice to hear the questions and try our best to give the advice. And I hope everyone found it helpful. Just the last thing for me, just one thing that I could have added at the beginning about do's. From my experience in terms of when startups eventually exit, one of the biggest issues I often see is EMI share options not being done correctly and a whole load of tax issues coming out of that, and founders often having to give sort of indemnities and maybe lose some of their sale proceeds. So my sort of parting point would be, if you can do EMI options, which a lot of startups do, please make sure you do them correctly. Otherwise, there might be some painful conversations and indemnities when you sell the business. But yeah, happy to answer any sort of questions and details with anyone. If you can contact me on LinkedIn.
Here, thank you very much. I have tagged all four of you on the live stream on LinkedIn, which will be available even after to view as a recording. So anybody tuning in via those live streams, feel free to reach out to our panelists today. Just two quick things before my parting words. Number one, as I've mentioned a few times today, if you tune in via the live streams, we're unable to monitor your questions there live. And I'm sure I'll see, because I've seen from my other phone quite a few pings on messages or comments, whatever they may be, on the live stream. So please remember, we are unable to monitor those questions live. So you'll have to, next time, if you want to ask our teams, you'll have to join us live here on Microsoft Teams. It's audio only. Quickest way to do that is to go to our website, startuptoscaleup.club. And then literally just click on whichever your preferred session is, click join. It's a quick registration, and that gets you a link to your email where you can join us. We do 6 regular sessions helping founders for free go from startup to scale up with on-demand tailored advice that works. And it's by people that have been there and done it. Those sessions are Mondays, talent, Tuesdays, product and tech, Wednesdays, growth, Thursdays, fundraising, second Friday of each month, as you saw today, startup legal. That's UK law, by the way. And third Friday of each month, it's UK finances for startups. That all from 12 to 1 p.m. UK time. And as I said, you can RSVP to any of them via site startuptoscaleup.club. When you're there, actually, join our WhatsApp community. It's groups of founders and investors and operators that you can interact with. And as far as my parting words are concerned, just remember the startup journey can be both exciting, but also quite challenging. So try to have some fun in the meantime and be kind to yourself and everyone else for that matter too. Otherwise, huge thanks. Have a great weekend. And hopefully we'll see you all for Startup Talent on Monday. Thank you and God bless. Bye bye for now.